Welcome to the course on medical law. This lecture will be about evidence law and medical experts. The concepts covered in this lecture are the opinion of medical experts, Section 45 of the Indian Evidence Act 1872, which is very recently modified through the introduction of new law, which is Bharatiya Sakshya Adhiniyam 2023 or the BSA. Under this new law, Section 45 in the previous legislation comes as Section 39. This lecture will also cover documentary and oral evidence and dying declaration as well. The keywords of this lecture are evidence, expert evidence, medical evidence, witness testimony and corroborative evidence. When someone is called as a witness in the court, they are expected to provide factual testimony only and not opinions. The court's task is to render a decision in this matter. It is expected that the witness who is called upon to testify must be someone who is actively involved in the case and not just a bystander. However, this is not always the case. So, who is qualified to be a witness in a case? A witness should be a person who has actual knowledge about the facts of the case. He should be an eyewitness or he should have heard something which he will be coming to the court and making a testimony. So, a witness is normally a person who has something to provide in the form of a factual testimony. So, normally witnesses are not expected to give any opinion. Whatever statement they will give is a statement of fact and not just an opinion. The individual opinions does not have any value when a witness is coming before a court and giving a testimony. But however, there is an exception to this. Expert opinion is an exception to this rule. In order to provide justice, the court needs opinions of specific experts or medical specialists on certain issues in order to have a comprehensive view. The same is justified by the argument that it is impractical to expect judges to be sufficiently knowledgeable about all types of different matters, including medical issues. So, normally a witness is not expected to give an opinion. He has to give a statement with regard to some factual aspect which is within his knowledge. But there would be certain scenarios in which an expert opinion will help the court in arriving at a decision or in finding the truth. So, in such cases, experts are allowed to come before the court, serve as a witness and give a statement. The Indian Evidence Act 1872 discusses the statutes pertaining to opinion of experts. However, the Indian Evidence Act 1872 was repealed and the new law Bharatiya Sakshya Adhiniyam 2023 was introduced in December 2023. So, now this new legislation covers the procedures and the substantive rule that has to be followed while a medical expert gives a testimony before a court of law. Why an expert is required? Without the assistance of an expert or someone who is having specific knowledge in a certain area, the court may not be able to come to an accurate decision. So, there would be scenarios where the question before the court will be of some scientific nature or will be a question of science, where some expert opinion or expert evidence will aid the court in arriving at an appropriate decision. The court calls an expert someone with a specialized knowledge when it needs an opinion on a matter requiring further help. If the witness is an expert, the third party's viewpoint is regarded as a pertinent information. So, expert evidence is the only scenario where a person can come before the court and give an opinion. In all other cases, the witness will have to make a statement which is based on fact. For instance, the court couldn't determine whether or not X is the author of a letter. So, now there is a dispute before the court, and the dispute is whether the letter was authored by a person called X or not. How can it be confirmed? If there is an eyewitness, then the eyewitness can come before the court and gives a testimony that he has seen X writing the letter. But if there is no eyewitness, how will you determine whether the letter in question is written by X or not? To confirm this, the court can consult a handwriting expert. So, a handwriting expert is a person who understands the science of handwriting and will be able to determine whether two different letters or two different documents are written by the same person having the same handwriting. This individual will be regarded as an expert, and advice he provides will be pertinent to the case. So, when the question is whether the letter is written by X or not, a handwriting expert can come before the court and gives an opinion as to whether it is written by X or not. How will he give this expert opinion? He will have to verify the document and compare the signature with some other letter or some other document which X has written. On making this comparison, the handwriting expert would be able to give a testimony before the court as to whether the letters are written by same person or not. Now, let us see the sorry, I am starting from here itself. Yes. There is no mistake, I am starting from this slide itself. Okay. Now, let us see the provision in the Indian's evidence law that provides for expert evidence. So, previously it was section 45 of the Indian Evidence Act, which was enacted in 1872, and now it is section 39 of the Bharatiya Sakshya Adhiniyam 2023. The section reads like this: when the court has to form an opinion upon a point of a foreign law or of science or art, or as to the identity of handwriting or finger impressions, the opinion upon that point of persons specially skilled in such foreign law, science or art, or in questions as to identity of handwriting or finger impressions are relevant facts, and such persons are called experts. So, now the court has to form an opinion as to, first example is the question is with regard to a foreign law, second is the question is with regard to science, third is it may be with regard to art, fourth is it may be with regard to identity of an handwriting, fifth is it may be with regard to finger impressions, sixthly it may be with regard to any other issue. In such cases, a person who is skilled in such foreign law, science or art or questions will be able to come and give a statement, give an opinion before the court as to what he feels. Such opinion will constitute expert evidence. The person who gives that expert evidence is considered as an expert. A medical officer's opinion can be used to demonstrate physical state of an individual's age, the reason for a person's death, the type of illness and the impact it has on body and psyche, the method or tool used to induce these injuries. So, we have seen different scenarios as given in section 45 and section 39 in the new law as to scenarios where an expert opinion could be given. Now, we are seeing in what all scenarios a medical officer's opinion will be relevant. So, for example, the question before the court is with regard to the physical state of an individual, whether the individual is physically capable of doing something or not. So, in such case, a doctor can examine him and give an opinion as to the physical capability of that person. Second is, the question is with regard to an individual's age. The individual is claiming an age which is being questioned by an opposite party. So, now a medical expert can examine him and give an opinion with regard to the possible age of that individual. Third one is, there is a question with regard to the reason of a person's death, whether a person has died due to natural cause or is there any other thing that has contributed to a person's death. So, who will be able to give an opinion on this? A medical expert can evaluate the corpse and give an opinion as to the reason for the person's death. Similarly, if there is a question with regard to the type of illness, impact of the illness, or if there is an injury on a person, then the question may be with regard to the method or tool used to induce the injury. In all such scenarios, a medical expert will be able to give a valuable opinion. So, should the court consider such valuable opinion? Yes. So, that is why we have a provision in the evidence law which facilitates giving of expert opinions. The moment the wound or wounds were sustained, that is another issue. When was the wound inflicted? How old is the injury? Whether the wound or wounds are life threatening. This could be another scenario where a person has died. Now, the question is whether the person died due to the injury inflicted on him. So, then the medical expert has to evaluate and then give an opinion as to whether the wounds which were inflicted is of life threatening nature. The cause of an illness, the symptoms, the characteristics, the potential after effects of an injury, on all these matters a medical expert will be able to give very valuable evidence. So, such evidence can be brought in before the court as an expert opinion under the evidence law. Now, let us see the importance of medical evidence. Medical science offers hints as to how the victim died and how the harm was inflicted. A person has died after he entered into a fight with another person, but it is also shown that the person was suffering from some heart ailments and had a heart attack just before his death. So, there is a possibility that the person may have died due to his heart ailment, but the prosecution is arguing that the person died as a result of the injury inflicted on him. Who will be able to resolve this puzzle? A medical expert can evaluate and give an opinion as to how the victim has died. Is it due to the harm which was inflicted on him, or is it due to the heart attack? For instance, what kind of weapon was probably used to cause the harm? On evaluating the injury inflicted, a doctor would be able to say the type of instrument or the type of weapon used to inflict the wound, how the wounds turned out, how they affected the victim, whether the wounds would have been enough to kill the victim in the normal course of events, how many stabs there were, and when they were likely to occur, the cause of death, etc. And all these matters, a medical opinion will be very valuable and aids the court in identifying the truth. Now, let us see the different forms of evidence. India's evidence law provides for two types of evidence. One is documentary evidence. All the documents submitted before the court is a documentary evidence. Oral evidence includes all testimonies from the witness regarding factual issues under investigation before the court. Documentary evidence comprises all the documents produced before the court for its review. There are mainly three types of documentary evidence which are given in medico-legal cases. First one is a medical certificate, second one is a medico-legal report, third one is exhibits. Let us see how valuable is a medical certificate. Medical certificate relates to illness, lunacy, old age, death and so on. When issued by a trained and licensed medical practitioner, it will be acknowledged by the court of law. The doctor usually, it is advised that the doctor should keep a copy of the certificate. When he issues a certificate, it is always advisable to keep a duplicate of the certificate. A doctor should never sign a death certificate before examining the patient's body and confirming that they are indeed dead. So, before the doctor issues any medical certificate, whether it is a medical certificate with regard to a wound or a disease or with regard to death of a person, it should be given only after properly examining the human body and arriving at his own conclusion. Even in the event that doctor's costs are not paid, the certificate shouldn't be delayed. Issual of a fraudulent certificate is a punishable offence under India's criminal law. Previously, it is 197 of the Indian Penal Code, which was amended, and the new law is introduced in 2023. Issual of fraudulent certificate is a punishable offence under India's criminal law. If a person who is a medical practitioner has been visiting throughout his sickness dies at the end, the medical practitioner is legally required to provide a death certificate detailing the death without charging as per the Registration of Births and Deaths Act of 1970. Now, let us see the value of medico-legal reports. Medical reports are written at the investigating officer's request. So, usually the investigating officer will request the doctor to give a medical legal report. Typically, these are required in criminal cases. An examination of the deceased person or an injured person is conducted on the basis of a request made by a police officer, and then the report is given. If the doctor does not appear in the court and testifies to the facts of the case under the oath, it will not be admitted as an evidence. So, normally once the document has to be admitted, then it is always advisable that the doctor appears before the court and gives a testimony. The reports are divided into two sections. It consists of facts, acts observed by the doctor during the examination, which will consist of all pertinent objective descriptions, including significant negative findings. The conclusion reached after considering the facts will also be a part of the report. When preparing the report, great care should be taken to ensure that no words are misused or statements are made in a careless manner. The report should include the identity of the person who is evaluated, or if it is a death certificate, the dead corpse has to be evaluated, as and well the date, time and location of examination also should be specified in the report. Superlatives and hyperbolic language should be avoided as far as possible in a medico-legal report. The medical practitioner's own observations of facts will serve as the foundation of the view and not the data which is gathered from the outside sources. So, this means that the medical practitioners should have to evaluate the patient by himself and give an opinion. He should not rely on data which is gathered from outside. If it is not possible to give an opinion right away, the injured party should be kept under observation and relevant investigation should be completed before a report is provided. The report should demonstrate the expertise of the person, the impartiality and provide specific expert guidance. The reports should be submitted immediately or shortly following the examination of the subject. The report should be clear, succinct, comprehensive and readable as possible, and it should stay away from technical jargons as far as possible. Now, let us see what is an exhibit. Exhibit is an item such as clothing, weapons that are submitted for medical examination. They also need to be thoroughly described in the report, sealed and returned to the police officer after the receipt is obtained. If it is possible to sketch the weapon's outline or record its dimensions, that also has to be done, and if it is done, the picture also has to be taken and kept in the record. Now, let us see what is oral evidence. Oral evidence comprises all remarks made by the witness regarding the facts under investigation that the court orders them to make or permit them to make. So, now let us see a case, State of Maharashtra versus Damu, which is a 2000 Indian Supreme Court decision. It was observed that expert witness may be examined and cross-examined. It has been established that opinion cannot be relied upon in its entirety without the expert being cross-examined as a witness. So, it is required under law that when a medical expert is giving a statement, then he has to come before the court and give a statement. So, once he gives the statement, the opposite party will get a right to cross-examine him. Now, let us see what is a dying declaration. A dying declaration is an oral or written declaration made by a person who is about to die as a result of an illegal act, detailing the relevant details of the incident that led to his demise or having impact on the situation according to section 38 of the previous version of Indian legislation or section 26 of Bharatiya Sakshya Adhiniyam, which is the new legislation. The declaration ought to be recorded by calling the executive magistrate if there is sufficient time. The physician should attend the patient's consciousness and normal mental abilities prior to recording the statement. So, dying declaration in effect is a statement or a written declaration given by a person just before his death. It has to be recorded in the presence of an executive magistrate, but if the executive magistrate is not available and sufficient time is also not available, then it can be recorded before other persons. Before the dying declaration is recorded, the physician should attest to the patient's consciousness, normal mental abilities prior to the recording of the statement. In the event that the victim's condition is bad and a magistrate cannot be immediately summoned to record the statement, then it is advisable that the physician records the statement in front of two different witnesses. Now, it is important to transcribe the man's statement exactly as he said without changing any words. So, when the dying declaration is recorded by a medical practitioner, he has to record it in exact words given by the patient. The statement from the declarant should be allowed to be made without undue pressure, outside encouragement or help. So, the statement which is recorded as a dying declaration should be the actual statement given by the patient. There should not be any modification, or it should not be taken after exerting undue pressure or outside encouragement to the patient. Now, let us see one case, Solangi Chibanbai Ukkabai versus State of Gujarat, which is a 1983 Supreme Court decision. Ordinarily, the value of medical evidence is only corroborative. It proves that injuries could have been caused in a manner alleged or nothing else. The use which the defense can make of medical evidence is to prove that injuries could not possibly have been caused in a manner alleged and thereby discredit the eyewitness. So, in case of a medical evidence, it is normally considered as a corroborative evidence. So, in order to prove that the injuries was caused in a manner said or argued before the court, then the party has to prove that the injuries could not possibly have been caused in the manner alleged, or thereby they can discredit the eyewitnesses. So, now let us see, unless however the medical evidence in its turn goes so far that it completely rules out all possibilities whatsoever of injuries taking place in a manner alleged by the eyewitness, the testimony of the eyewitness cannot be thrown out on the ground of alleged inconsistency between it and the medical evidence. So, that is why the evidence given by the eyewitness or the testimony of the eyewitness is placed on a higher pedestal compared to the medical evidence. But if the medical evidence can prove that whatever is said by the eyewitness in his testimony is not at all believable, because it rules out completely all the possibilities of injuries as explained by the eyewitness, then the medical evidence becomes very valuable. Otherwise, if the medical evidence is only showing a probability which is not enough to contradict the statement given by the eyewitness, then it does not have much value. But if it can completely rule out all the possibilities whatsoever of injuries taking place in a manner alleged by the eyewitness, then the medical evidence take precedence. Now, let us see one case, Mayur versus State of Gujarat, which is a Supreme Court decision from 1983, which says that even where a doctor has deposed in the court, his evidence has got to be appreciated like the evidence of any other witness, and there is no irrebuttable presumption that a doctor is always a witness of truth. So, when a doctor gives a statement before the court, it is considered like any other evidence which has come before the court. So, an evidence given before the court has to be proved. So, the role of the court is in identifying the truth and arriving at the correct decision. So, all the evidences has to aid the court in arriving at the correct decision. So, when a statement is given by the doctor, it will be considered as any other evidence, and there is no irrebuttable presumption that the doctor has given a correct statement or whatever the doctor has stated is the truth. Now, let us see another case, Nagendra Bala versus Sunil, which is 1960 decision, which says that medical evidence is indirect. Its value comes only from its ability to corroborate and strengthen eyewitness direct testimony, reduce the testimony and eliminate any chance that the injury could have occurred in a way that the witness claimed. A doctor's opinion should be given a lot of weight, yet it may also be discounted for valid reasons. So, this is what we have previously seen. Medical evidence isn't a direct evidence. So, it is only an opinion. So, eyewitness testimony always has greater weightage compared to an opinion given by an expert. But if the expert opinion completely rules out all the possibilities of truth existing in the eyewitness testimony, then the medical evidence becomes valuable. But if it cannot rule out all the possibilities, it only suggests that the eyewitness testimony may not be believable, then eyewitness testimony has more validity than the medical opinion. To conclude, the testimony of medical experts is very important and helpful during the trials. The opinions are founded on medical officers' observations of the deceased or the injured person's bodies following the incident. So, he has formed his opinion after proper examination of the body of the deceased or the injured person. Given that medical officer is an expert witness, considerable weightage will be given to his testimony. But at the same time, there is no irrebuttable presumption that medical officer is always telling the truth, but rather his testimony will also be assessed and valued similar to any other testimony given before the court of law. The references of this lecture can be seen here. Thank you very much for listening to this lecture. I hope you are enjoying the course.